Respondent in the matter, Commissioners for His Majesty's Revenue and Customs against Vermilion Holdings.
This appeal by the Commissioners of HM Revenue and Customs, whom I will refer to as HMRC, involves a question of the interpretation of a taxing statute. Under Section 471 of the Income Tax, Earnings and Pensions Act 2003, gains made on the exercise of a share option may sometimes be subjected to income tax rather than capital gains tax if the option giving rise to the gain was, or is treated as if it were, an employment-related securities option. The facts, so far as relevant, may be simply stated. Mr. Noble, a specialist in corporate matters, including mergers and acquisitions, assisted a start-up company, Vermilion Software Limited, to obtain funding in a funding exercise in 2006 by creating a business plan and financial projection and providing other services. A new company, Vermilion Holdings Limited, which I will refer to as Vermilion, was created. Mr. Noble's nominee company, Quest Advantage Limited, was given an option to acquire 2.5% of Vermilion's share capital, and the option was to last for 10 years. Unfortunately, the company soon needed to be rescued as it was running out of working capital. A rescue plan was devised in 2007 by which Mr. Noble became executive chairman of Vermilion. New capital was invested in the company, a new share structure was agreed, and Mr. Noble's share option was replaced by a new share option which would enable him to acquire up to 1.5% of the share capital of the company, thereby reducing his reward. The new share option was available for 10 years from 2007. In 2016, when it was proposed to sell Vermilion's shares to another company, it was agreed to novate the share option agreement so that Mr. Noble replaced his nominee Quest as owner of the 2007 share option. On the exercise of the share option, Mr. Noble's advisors sought the agreement of HMRC that the exercise of the share option would subject Mr. Noble to capital gains tax, not income tax. The rate of capital gains tax was considerably lower than Mr. Noble's marginal income tax rate. HMRC decided that the share option was an employment-related securities option and that the gain on its exercise counted as employment income, rendering him liable to income tax and national insurance contributions. HMRC claimed the tax and contributions from Vermilion as his employer, but as Mr. Noble had indemnified the company against the tax consequences of the transaction, it was he who has the economic interest in this appeal. Vermilion appealed to the first-tier tribunal, who found in its favour. The upper tribunal decided in favour of HMRC on the basis that the option was an employment-related securities option based on Section 471, subsection 1 of the Act, namely because it concluded that the option had been made available to Mr. Noble by reason of his employment. Vermilion appealed that decision to the Inner House of the Court of Session in Scotland. The majority of the Inner House decided the appeal in its favour, the Lord President dissenting. The question on this appeal is whether the majority of the Inner House was correct. Before this court, HMRC argued both that the option was, on the facts found by the first-tier tribunal, made available to Mr. Noble by reason of his employment. That is the factual test in the first subsection of Section 471. and that in any event the deeming provision in subsection 3 of that section applied, so that the option was deemed to be made available by reason of his employment as a director of Vermilion. This court decides the matter solely by reference to the deeming provision in subsection 3 of section 471. Subject to two exceptions which do not apply in this case, subsection 3 provides in short that the right to acquire a securities option made available by a person's employer is to be regarded for the purposes of subsection 1 as available by reason of an employment of that person. Subsection 1 asks the question of causation. Was the option made available by reason of the employment or some other cause? Now, that can be a difficult question to answer if the facts are complicated. As the court explains, a deeming provision such as subsection 3 creates a fiction. The court gave guidance on the scope of deeming provisions in a statute in its judgment in 2020 in the appeal of Fowler and the Commissioners of Revenue and Customs, a key passage of which is cited in the court's judgment today. The extent of the fiction is primarily a matter of interpreting the statute, having regard to the purpose for which the fiction was enacted. The court shouldn't apply a deeming provision so far as to produce unjust, absurd, or anomalous results, unless it is compelled to do so by the language of the statute. In this case, the deeming provision produces no unjust, absurd, or anomalous results. It instructs the court to ask, who conferred the right? Here the question is, did Vermilion confer the option on Mr. Noble while he was its employee? And the answer is, it did. The answer to that simple question avoids the need to address causation under subsection 1, on which the judges in the tribunals and the court below reach differing views. In other words, the purpose of this deeming provision was to create a bright-line rule to be applied, and by that means avoid complex issues of causation. In this case, Vermilion was at the relevant time Mr. Noble's employer. It gave his nominee company the share option. Therefore, the option is deemed to be made available by reason of his employment. This court unanimously allows HMRC's appeal.